Good afternoon. I'm Michael Heiger, and with me today is
Gina Clausen-Lozier.
And we're both with the Berger Singerman Law Firm, which is a full-service law firm located in Florida. We have offices in Miami, Fort Lauderdale, Boca Raton, and Tallahassee, and we represent clients with their needs in a wide range of matters, ranging from real estate, corporate, tax, as well as litigation. And today, both Gina and I are in the insurance practice group of Berger Singerman, and the two of us lead that practice group. And today we will be speaking on After the Storm, What an Association Needs to Know. This course is intended to provide attendees with a guideline for reporting, documenting, and mitigating a property loss. In addition, this course will advise and educate attendees on the common insurance policy conditions and provisions which insureds and or their agents are obligated to comply prior to and during the insurance company's claim investigation. Too often, when a casualty of some sort occurs, the insured, the policyholder, in this case the association, whether it be a condominium association or a homeowners association, does not know what conditions are in their policy that they're required to comply with in order to preserve and pursue an insurance claim. Today, we will try to answer those questions for all of you. There will also be a discussion regarding the retention of public adjusters, remediation services specialists, and other expert professionals. These are all types of individuals who regularly get involved when an insurance claim occurs, and in which an association, when faced with an insurance claim, should have some knowledge about in order to intelligently navigate the process. Moreover, this course will conclude with a discussion on the appraisal process and what happens when and if a claim is denied. So let's first start with some of the basics.
Hold on one sec, we're just trying to get the PowerPoint to move to the next page. Okay. Some of the basics that we're going to talk about today are how you should report a loss and the duty to provide notice after the insurance claim has occurred. What are the insured's duties after a loss? What can an insured expect from the insurance company's claim investigation? Should an insured hire experts? And what if the claim is denied? So one of the most important things that associations need to know about their insurance policy is the obligations for reporting a loss. All policy provisions have certain duties and obligations that the insured must comply with following the loss or event that would result in an insurance claim. These duties are called generally post-loss conditions or post-loss obligations. The failure to comply with any of the post-loss conditions under the policy could result in a delay of claim payment or, at worst, the denial of coverage under the insurance policy. We're going to discuss various different post-loss obligations and conditions, but the very first one that often comes about is, when do I have to give notice of the loss? Policies both on the residential side and the commercial side for homeowners associations and condo associations have what's called a duty to give prompt notice. Typically, the policy provision says something along the lines that you must see that the following are done in the event of a loss or damage to cover property. Give us prompt notice of the loss or damage, including a description of the property involved. Now, nowhere in the insurance policy is the word prompt defined, but typically under Florida law, giving prompt notice of the loss is to provide notice to the insurance company as soon as a reasonable person would believe that they had damages that could potentially give rise to an insurance claim or potentially eventually be covered under a typical insurance policy. The law does not take into account the reason why an insured would potentially fail to give prompt notice of the claim. We often hear in our cases from our clients that oh, we didn't think it was over the deductible, or we didn't think it was going to be covered. Making those assumptions at the outset of the claim could be detrimental in the process of an insurance claim and the claim investigation. Specifically, with respect to the deductible, oftentimes when a claim is reported to an agent may advise the association or another insured that they don't think the damages give rise to reporting a claim or that the premiums may go up. This is detrimental advice to a certain extent because if you fail to give prompt notice of the loss, once it is determined that the notice is late or not prompt under the insurance policy, what happens is there's an automatic presumption of prejudice that attaches to the insurance company, and they have allegedly then been prejudiced. The burden then shifts to the insured to try to overcome that prejudice.
So when you have when you or the association that you manage has a loss, whatever that loss is, at the outset, let's presume that the loss is covered, meaning that it falls within the coverage provisions of the loss, of the insurance policy. But if you or the association that you manage fails to timely report the loss and fails to properly do so, then what potentially may happen is you forfeit your coverage. So that means that you had a loss that was covered under the insurance policy, that you or your association would have the right in which to obtain indemnification benefits from your insurance company, the benefits that you or your association paid premiums for, only to have them forfeited because there was a failure to comply with a policy condition. In this case, the condition being timely and properly reporting a loss. So you can see why that would be critical right from the outset to conduct the proper analysis as to what to report and when to report, and to make sure that you do so timely and properly, because one certainly does not want to be in a position where there was a loss that was covered and you forfeited coverage by failing to timely and properly report it. So Gina, let me ask you some questions. There are certain things that an insured ought to consider when it comes to reporting a loss. What should be reported?
Well, the insured should report essentially an overview of the damages. Typically when a loss first occurs, you may not know the actual event that caused the loss. In the event of a hurricane, obviously you know that a hurricane had passed through and you're going to advise the insurance company accordingly. But in the respect of other losses, such as plumbing losses or other particular perils, it's good to do an investigation before you report the loss so you don't tie yourself to a specific cause of loss.
Well, let me pause you there. Sometimes, especially, for example, with water losses that can be insidious, especially in a condo association where there's multi-units, you have a leak. You can tell that you have a leak coming from somewhere, but you don't know where it is. So what should you tell your insurance company and so that you accurately report the loss to your insurance company?
I think it's exactly that, listen, us as the association, we know that there's water intrusion. We haven't identified the source, but we believe that there's damage that could potentially give rise to the insurance claim, and then the insurance company will do their investigation, which we'll get into a little bit later today in the presentation, and hopefully assist in determining where the loss had come from.
Now, once you figure out what you should report, or at least have some sense of that, who should report the loss?
Generally speaking, when it comes to an association, they either deal with property managers or differing board members. We would suggest, however, that an association designate one person to deal with the insurance claim and report the loss. So there's consistency with respect to what is reported and what documentation would be produced. Oftentimes that goes through property managers, sometimes it would go through the insurance agent, and sometimes it would go through the president of the board.
Is there anything that, let's take a condominium association or a homeowners association, is there anything that they ought to think about when deciding who is the person whose name will be attached with the reporting of the loss?
Yes, absolutely. And as we'll get further into the presentation, we'll discuss some additional post-loss obligations. But you want to identify someone who has some knowledge and history at the property if possible, because likely the insurance company's claim investigation is going to involve an inquiry regarding the history of the property, the repairs that have been made, and you want someone who's going to be able to answer intelligently about those issues. Additionally, if to the point that the claim goes further and may eventually go into litigation, you want a representative of the association who is going to come across as a person who we want representing the association as far as being able to clearly explain the issues the association is having and professionally have a kind of a professional demeanor to represent the association moving forward.
Is there any consideration as to how the loss itself should be reported to the insurance company?
Typically, we see on the commercial side that there's either an email sent to the insurance agent or there is a phone call made to the insurance company directly. The insurance company will then fill out what's called a first notice of loss and send an acknowledgement letter.
Or an accord form?
Or yes, an FNLO accord form is really what you'll typically see. But make sure that when you do report the loss, if it's done over the phone, that you record the time and the date and who you spoke with and what phone number you called from and what phone number you did call. That way, if there's any questions regarding whether the notice was prompt or not, you can clearly explain to the insurance company exactly when that phone call was placed.
Do you recommend that the insured or the representative of the insured follow up in some way in writing to make sure that there's a paper trail documenting that a call was made or that a communication was made?
Yes, absolutely. If you have confirmation of an email address or a physical address for the insurance company, you can send a letter saying, this will confirm that we reported a loss on such and such date. You can also send an email to your insurance agent or other representative to confirm that the loss was in fact put in. The insurance company, once they receive the loss notice, will kick out an acknowledgement letter assigning you a claim number, and at that point you'll have a little bit more information as to who will be the primary contact on the insurance company's behalf.
And then lastly, and we touched on this right from the beginning, when should the loss be reported? The
loss should be reported, as we discussed, as soon as a reasonable person would believe that there'd be something to give notice of a potential insurance claim. If a hurricane comes through and there's obvious roof damage and interior water intrusion, at that point the association would need to go ahead and put that loss notice in.
What happens and what should you do if you're an insured if you don't know that you have a leak? For example, let's say you see some staining on some roof tiles, or you see some buckling of some floor tiles, or all of a sudden you see a spike in your power bills or in your water bills. What would a reasonably prudent, reasonably careful homeowner association property manager do under those circumstances?
If there's something that seems out of the ordinary with respect to the property, you're going to want to undertake some type of due diligence to determine whether there's a deeper issue. It may be something that is not worth much further investigation, but you will want to go ahead and determine what the cause of that would be, because it's something that's out of the ordinary to see these types of leaks. And you're going to want to figure out where those leaks are coming from. Now, it may be that you need to do a little bit more investigation before you put the insurance company on notice, but taking those steps will absolutely help protect your rights to recovery in the long run.
Just a follow-up to that, Gina. You notice, for example, that you have some floor tiles, for example, that seem to have buckled. What, if anything, should you do as part of your investigation in terms of drilling holes or changing the way in which the scene appears when you first observe it?
Well, with respect to the duty to give prompt notice under an insurance policy, that duty is there because the insurance company has the right to inspect the property and complete a loss assessment. If during the course of the claim and prior to reporting it, you alter the condition of the property, that is going to be it may be troubling later down the line to the insurance company. So if emergency repairs are necessary as a result of a particular peril, you know, you should take photographs of the property, video when necessary, have documentation of what repairs were made, keep an accurate record of repair expenses. But generally, if you could preserve the property, you would want to do that so the insurance company could inspect it.
If you have what you perceive to be an emergency situation, is there anything that you should do in terms of your communications with the insurance company so that they're aware of your need for making immediate repairs?
Absolutely. You should advise the insurance company that, you know, you're an association, you have a duty to your residents and unit owners, and that emergency repairs are necessary. Put them on notice that the emergency repairs are going to be taking place immediately, and let them have the opportunity to come out if they want to. But ultimately, you need to protect the property and protect the health and safety of the residents, and you have an obligation to mitigate your loss as well.
So now let's turn to the next slide, which we touched on earlier before, actually one back right, and which you touched on in your opening remarks, Gina. What happens if the policyholder, the association, fails to give prompt notice?
Well, under a typical insurance policy, if there's an exclusion to a loss, the insurance company has the burden to prove that the loss isn't covered. Under the prompt notice provision, there is an automatic presumption of prejudice in favor of the insurance company.
When does that presumption arise?
The presumption arises if it's a failure to provide prompt notice, if there's a finding that, for whatever reason, the notice of the claim was late. And there's really no time period defined as what late would be. It could be a week, it could be a year. It just depends on the circumstances of each particular claim. So
if I'm a property manager, how do I know what prompt means?
Prompt means, under Florida law, is that as soon as a reasonable person would have some information to give rise to a potential insurance claim. So in the example that you said, if you see leaks on the ceiling, or you see a huge spike in water bills, at that point, a reasonable person may be led to believe that there's something more substantial going on here.
Does the law impose any hard and fast benchmarks under which a property manager or any policyholder would be able to work under to know? So, for example, 3 months is the limit, or 6 months. Is there any hard and fast rules to follow?
There is not in Florida. As I said, there's case law that interprets this provision that a week late is not prompt. Sometimes it could be 2 days. It really depends on whether the insurance company's ability to investigate the loss has been frustrated, such as if repairs are made and there's no photographs or there's no video and the scene of the potential losses has been altered. At that point, you know, it may be hard to overcome that presumption of prejudice.
So let's say, despite all my best efforts as a property manager, somehow we fail to give prompt notice, and it's determined that we failed to give prompt notice. Is that the end of the claim for our client? It's
not the end of the claim. There's a two-step analysis under the prompt notice provision. The first, as you said, is there has to be a determination that the notice was in fact late. The second step under that is whether the insurance company was in fact prejudiced by the failure to report the loss. Now, the burden to show that the insurance company was not prejudiced is on the insured. It would be on the association to say, hey, here's all the evidence we have for the insurance company to investigate. They could not have been prejudiced by our late notice because we were able to overcome it.
And are there practical ways to overcome such prejudice?
Yeah, there are. One of the main things to overcome prejudice is, as we stated, is to take photographs. Photographs are key evidence to be able to show the condition of the property at and immediately after the time of loss. Videos, if possible, records of repair expenses, if possible. If emergency repairs are made, make sure you have the contact information for the person who made those emergency repairs, because ultimately you may need them to help support your position in front of a jury.
Well, we're here today during Hurricane Preparedness Week. So is there anything that you would want to remind associations to do in terms of auditing their premises before a casualty occurs?
Right. Oftentimes, once you have a claim, the insurance company is going to request certain documentation from you. So it's prudent for the association to take photographs of the property now prior to being faced with the threat of a hurricane to document the condition of the property as it exists today. Oftentimes, the insurance companies will assert different exclusions to a loss, such as, you know, wear and tear, lack of maintenance, or other various exclusions to knock out coverage for the association. But if you have documentation of the property as it exists today, you'll clearly be able to show, here it was prior to the loss, there was a certain event, and here's the condition after.
So then an ounce of prevention, if you will, taking some steps on the front end may have significant benefits to you on the back end when and if, God forbid, you do have some type of casualty.
Absolutely. I mean, documenting the condition of the property now, or, and you know, there's also some additional obligations with respect to documenting the actual physical files and the documentation, the records that the association is going to have to eventually produce. Having this stuff all teed up and ready to go will expedite the claim process because you're not going to have delays for the association to gather all the records for additional production. So having it all ready, available to go once the requests come in will absolutely help get the claim hopefully paid on a quicker track.
And perhaps negating certain exclusions or arguments an insurance company might argue to get around coverage.
Right. You know, that the compliance phase is very important under any insurance claim, and having the documents and records and the tips in place and the plan in place now for when an insurance claim needs to be reported will help avoid some of the arguments an insurance company can make.
Okay. Next, some practical tips for reporting a loss. I think you have touched on most of these earlier, but if you could expand on that a bit.
Yeah, take notes of the conversations with the insurance company's representative, find out who's involved, when they're coming out, who the independent adjuster is. You ask when you should receive a response. Get the inspection scheduled right away, especially if there's an issue with potential emergency or temporary repairs and loss of use of the property. You want to get that inspection set. You don't want to leave it open-ended, so really push to get a date and document everything. And hopefully you've already identified a point person to deal with this so they can keep an accurate record of their conversations and of their notes, because it's going to be important later down the line.
Now, we've been talking about losses mostly in general that might occur to a property. Are there different time restrictions involved when it comes to hurricane losses?
Yes. Generally speaking, under a property insurance policy, you have 5 years to file a breach of contract action with respect to an insurance claim. Under a hurricane claim, you have to give notice of the claim or supplemental claim or reopened claim within 3 years after the first hurricane made landfall or the windstorm caused the covered damage. If you fail to do that, then and you don't give that notice, you could be barred from further reporting a claim.
You use the word supplemental. Our listeners may not know what you mean by that. What does supplemental mean in the insurance context?
A supplemental claim, generally speaking, is damage that may occur not at the original time of the loss, or you may not have realized it at the original time, but later on down the road, it becomes evident that this was related to this particular claim. Say, for example, you have roof damage from a hurricane, and at first glance you think that the roof damage is minimal, and the insurance company then pays you, and then you realize that the roof damage is actually more extensive than you thought, and it's now causing interior water damage. You go back to the insurance company and say, hey, listen, this is related to the first event, but there's further damage that needs further addressed. So moving on from some of the late notice, there's also other obligations under the property insurance policy and conditions that you need to comply with. And one of those conditions is preserving the property. Michael, can you explain really what the purpose of preserving the property is under the insurance policy?
Sure. Once again, the insurance policy is going to have obligations for the insured, the policyholder, the association, to comply with. And these obligations are not just to make an insured's life more difficult, although it may seem like that at times. The real purpose behind these conditions, and in particular a condition involving preserving the property is so that the insurance company has the opportunity to be able to come out to the property, fully investigate and inspect the property, and be able to assess what were the damages, how did the damages occur, and whether or not there's coverage for the damage, and whether any other applicable provisions which may affect coverage are applicable with respect to the loss. And from the insurance company's perspective, the best way to do so is to be able to come out to the property reasonably soon after a loss occurred, because that's when everything is fresh in terms of what the scene looks like shortly after a loss occurred.
So let's take, for example, a plumbing loss. If the insured has a plumbing loss, is the association required to keep the rusty or broken pipes?
The short answer to that question is yes. And so if, for example, it's 1:30 in the morning on a Saturday night, and all of a sudden a pipe breaks, and somehow the association finds the only plumber in the world who works at 1:30 in the morning on a Saturday, who comes out to the property, cuts the pipe, patches the pipe, and is ready to throw away the broken pipe that was the source of the leak, the property manager or whoever is overseeing this repair should insist that the whole repair be documented, video or by photographs, and should also make sure that the pipe itself is preserved. And the reason for that is because at 1:30 in the morning, of course, on a Saturday night, it's unlikely that the insurance company is going to be able to send out a representative to inspect and see that damage for themselves. But if you preserve the property, preserve the damaged pipe, you do everything you can to properly document the scene so that the insurance company can see the scene exactly or as close to exactly as it occurred, then the insurance company will not be prejudiced by virtue of the fact that it did not have the opportunity to get out there at the time. And with respect to the pipe itself, by preserving the pipe, it allows the insurance company then to conduct whatever forensic investigation it wants to conduct with respect to the pipe. At the moment, as to the failure of the pipe, it may not be clear as to why the pipe failed, but the cause of the failure of the pipe may have an impact on whether it's covered or not covered under the insurance policy. So by preserving that pipe, it gives the insurance company the opportunity to do whatever forensic investigation it needs to do in order to determine whether or not the loss is covered or not.
Now, what about in the context of the property that can't be preserved? I mean, oftentimes you have a water loss and the drywall is so damaged that it can't be preserved and it has to be removed from the property and demolished somewhere in that process. What happens then?
Once again, what's really critical here is that the association makes every effort possible to document what it does. So in the example that you gave, drywall or other material that is not really capable of being salvaged or maintained in some way, what you want to do is through photographic evidence, try to preserve or try to document what steps you took in order to mitigate the damage and what steps you had to take to repair and mitigate and modify the scene, so that the insurance company once again has an opportunity to observe what you did and to observe what the condition was at the time of the loss, and et cetera. And so from the standpoint of the insurance company, you want to always be thinking, what can you as the association do to give them as much information so that they are not prejudiced as a result of the fact that you had no choice but to change the condition of the scene.
And what happens if you ultimately aren't able to preserve the property for the insurance company's inspection?
Well, again, it's going to come down to the circumstances, but if the circumstances are such that you've got wet drywall on that's hanging on the wall, and for whatever reason, maybe it's going to be days or even weeks for some reason. Sometimes that happens in a hurricane where it's going to be weeks before an adjuster is going to be able to come out to the property. Then you also have other obligations under the policy to take reasonable steps to mitigate. And so those two obligations have to be balanced, and it's still going to come back to documenting what happened so that the insurance company is not prejudiced. And I would say, and I certainly would advise my clients, that when you're balancing those two competing obligations, that you have just as much of a responsibility to mitigate your damage. Because, for example, with wet drywall, that's going to lead to mold here for certain in South Florida, given our humid conditions. And you certainly don't want to have moldy drywall hanging on the walls for a couple of weeks while you're waiting for an insurance company's adjuster to come out to the property. Another thing that you can do is you can communicate with the insurance company and let them know under no uncertain terms that you are about to undertake certain steps and that you have no choice but to undertake certain steps, and to give them a deadline to come out and look at the scene before you have to change it.
Now, one of the things you said was documenting the loss. Can you describe what you mean by documenting the loss?
Well, sure. So documenting the loss can involve a number of efforts. One, we've talked about photographing the damage, and photographs are certainly a powerful tool to show the damage. Today, anybody would be hard-pressed to say that they are not capable of taking a photograph. Every one of us, or nearly every one of us on this planet today, carries a smartphone with them. And so you can start by taking photos on your smartphone. Obviously, of course, you could take more professional photos as well, but you certainly have the ability right from the initial event to start taking photos on your smartphone or some other device. Similarly, today, you can video the occurrence. We just had a case recently where the rain was flowing down in this commercial space from the roof and coming down in buckets into the interior space. And the insured documented that water flowing down with a video. Absolutely no question that rain was coming in from the roof, through the ceiling, and into the interior space, because that insured videotaped what was occurring in real time as it was occurring. There are, of course, other ways to also document the loss. You can document the loss by making sure that every vendor that you deal with in terms of the process does so in writing with you. For example, after Hurricane Andrew and some of the other post-1992 hurricanes, it was not uncommon, meaning it was common, that handyman and other types of fly-by-night type people who were trying to help or perhaps make a quick buck provided services to insureds for certain services. And on a property such as a condo association, which might have hundreds of units, you may have a maintenance person who makes repairs. So you want to make sure that if you have repairs made, that you document them in some way in writing as well, even if they're done by an internal person. If you're going to pay for them in cash, make sure there's some paper trail to reflect that they were paid for in cash. If you're going to handle it with some outside vendors, oftentimes, for example, mitigation companies will be very fast on the scene with blowers and other devices to dry out the scene. Again, you want to make sure that you have invoices and receipts and other documentation. Perhaps you had some type of theft at the property. Then you want to document it with a police report. The point is that at every step of the way, you want to make sure that you document everything that happens in writing and electronically if possible. Another thing that you need to be mindful of, and this is something that you, especially for associations, you need to be mindful both before, during, and after the event, what you record in your minutes. Condo associations in particular are well known for documenting everything in their minutes. Everything from the fight that Unit 101 is having with Unit 103 about the fact that the cat is always, bothering them or something, to there are leaks in the ceiling and they're complaining about it. And the reason that you want to be very careful always in terms of what you document in your minutes is because someday, if you have a loss and an insurance company comes out, it's going to ask for a boatload of information. And that boatload of information is going to include all of the meeting minutes going back to the beginning of time, and it's going to have an impact on the coverage for your claim, because they're going to ask for meeting minutes not just at the time of the loss and after the loss, but also before. So if you have meeting minutes prior to the loss that reflect that the ceiling was leaking in Unit 101 for months on end, and then you report a loss and you say that there's leaks in Unit 101, the insurance company is going to look at that and say, wait a second, your meeting minutes reflect that Unit 101 was suffering roof leaks long before you claimed that there was an event that caused leaks to Unit 101. So you want to be very careful what you say in your meeting minutes, because they may come back to bite you. And the same is true after a loss. The way you communicate and report what happened after a loss could affect how the insurance company and how a court of law may perceive what you communicate in your notes. So, for example, if on day one you say you had a loss, and then in the meeting minutes you minimize the damage or say something that seems to suggest that the loss either did not occur or was not very significant, and then later you make a multi-million-dollar claim with respect to that loss, that's going to affect your claim ultimately.
Now, Michael, one of the other things that we were kind of discussing is mitigating the damages. And generally speaking, mitigating the damages after a loss means to take all reasonable steps necessary to protect the covered property from further damage. One of the basic examples of your ability to mitigate a loss is in the context of a roof leak. If you have a tornado or a wind event that causes some type of roof damage and you fail to tarp the roof or make temporary repairs, and further interior damage occurs resulting from that roof, the roof damage, the insurance company may have an argument that they don't owe you any additional coverage for that interior damage because you failed to take the steps necessary to protect the property. Now, sometimes this condition can kind of conflict with your obligations to show the damages to the property as well. So you do need to be careful to, again, as Michael had suggested, document everything. Now, with respect to considerations when mitigating the damages, we talked about this within context of showing the damaged property. You always want to clean everything up, but if it's possible, to preserve that property and don't throw things away. In the event that there's a plumbing loss or a substantial water leak, you want to try to shut off the water supply, or in the event that there is water in an area that's subject to the electrical system, you may want to turn off the electricity as well. This is obviously to prevent further leaks, further damage, or potential fires if there's water intruding into the electrical system. Also, to hire remediation service specialists. There's a lot of companies out there right now who offer remediation services to do so on an emergency basis to put fans and dehumidifiers in the property. But we also do caution that if the association is going to sign a contract with a remediation company or a water extraction company, that you clearly read the contract, because most of these contracts at this point in time contain what is called an assignment of benefits. And that can get you into a little bit of a sticky situation down the road with the insurance company by essentially assigning your insurance claim benefits to a third party, such as a remediation contractor. So in the event that you are asked to sign one of these contracts, we definitely suggest you review it very carefully, discuss it with the board, and likely discuss it with your condo attorney as well.
Because one of the things that's going to happen when you have a loss, especially a significant loss, is that all of a sudden you're going to become very popular with a number of different types of mediation or remediation specialists who will be claiming that they can come out and provide all kinds of services to you. So, of course, you want to make sure that they're licensed. But more importantly, the time to think about these things is before a loss occurs, not after. And so that you have at your ready the names of the different types of specialists that you would want to call out if something happens. And again, most people tend to think we can sign a contract with a mitigation specialist of some sort or any type of vendor, and we don't necessarily need to show our lawyer that contract. But as Gina mentioned, and we really do emphasize this, it's really important to make sure that whether it's your condominium attorney or your general practitioner or somebody like Gina and me who specialize in this area, that you have someone who knows and is knowledgeable about these types of contracts to review that contract, because when you sign that contract, it may obligate you and the association to consequences that you would not want to be obligated to.
Now, okay, let's assume that the loss was reported and at the insured put prompt notice into the insurance company, and ultimately the insurance company is going to complete a claim investigation. Can you, Michael, describe what can generally be expected from a claim investigation?
Sure. So you're going to have a number of things that are going to happen once you give the insurance company notice. The very first thing that you can expect is that the insurance company is going to send someone, a representative, in all likelihood an insurance adjuster, to visit the property in order to make an inspection of that of the property. And the insurance company adjuster, in all likelihood, is going to come with a camera, and these days probably a smartphone, and take photos all over the property in order to document the condition of the property. The person who comes out may also walk around the property in order to get a general sense of the condition of the property overall, and will likewise be taking photographs of the property in order to assess the damage or assess the condition of the property. That adjuster may also walk around and talk not just to the representative from the insured, the association, but may also wander around and talk to others as well. Recognize that the insurance adjuster, generally speaking, is not there to help the insured, but rather is a representative of the insurance company and is looking for reasons that there may be limitations on or exclusions with respect to coverage. So it's very important at that point, right from the beginning of the inspection, to be aware of these requirements and to be aware that you are in what I would call, at a minimum, a semi-adversarial situation.
And Michael, you hit on a good point. Often we hear our association clients say that, oh, our adjuster is coming out, but typically that would be the independent adjuster. And, you know, there are individuals, Michael, right, that would represent an association. Can you describe the difference between the independent adjuster and an adjuster that would work on behalf of an insured?
Sure. Well, let me start with the misnomer, which is the insurance company's adjuster will call himself or herself an independent adjuster. And that term is a bit of a misnomer. When they say that they're independent, they don't mean that they're not biased or that they are not working for anyone or that they're neutral. Make no mistake about it, an adjuster, someone who calls himself or herself an independent adjuster, works for the insurance company. The way in which the term independent comes about has nothing to do with whether or not they work for the insurance company. In fact, what it means is that the insurance company has hired a third party to do the adjusting for them, and that their contract is with this third-party company, and for that reason, they're allowed to call themselves independent. But they're not independent by any means. So many, many years ago, really hundreds of years ago, but only became in vogue and very, very popular, at least in Florida, after Hurricane Andrew, was a public adjuster. And a public adjuster is much like what it sounds like. Public adjuster means an adjuster who represents the public, the consumer, the condominium association, the homeowner, the homeowners association. And the job of a public adjuster is to communicate directly with the insurance company's representative and to act as the representative of the homeowner or the association, and to help the insured maximize their claim and make sure that the insured gets an adjustment, an assessment of their claim, which is the full amount that they're entitled to under the insurance policy.
So one of the other compliance issues is the production of documents. All insurance policies require insured to produce records, and in the context of an association, the insurance company has a right to come out and actually inspect the books and records. And Michael had briefly discussed that point with respect to when you put things in your meeting minutes. I, as a former defense attorney, have spent countless hours pouring through association records when I was investigating insurance claims. So when the insurance company does request documentation, they will absolutely review those documents. And if you do not have these documents readily available, now is the time to start thinking about how these records are maintained. In the event that you have a loss, is it going to be necessary to send someone to a basement to pour through bankers' boxes of records that are in no particular order, or are your records in a manner that could easily be identified? Now, the insurance company has pretty much broad discretion as to what they can ask you for a document production following a loss. The only requirement is that it has to be reasonable and it has to be somewhat relevant to the claim. But in the context of an association, they will ask for financial records, estimates, invoices, documents of mitigation efforts, meeting minutes, the financials. So these documents are necessary to both keep accordingly pursuant to the statute that requires you to keep them, but also to help assist in the submission of an insurance claim. Now, we're running a little short on time, so we've talked about a lot of these provisions. But Michael, the sworn statement of proof of loss is one I think that the association needs to have an idea of what it entails.
Sure, this is an important legal document, and I emphasize the word legal document because, again, this is a document that's generally it looks like a form, and different insurance companies use different forms, but the content and the substance of these forms are generally the same. But like I said, I emphasize that it's a legal document because oftentimes an insured, especially a commercial insured, one who typically operates under the presumption that they're sophisticated, they're capable of filling out such a form. But I would caution that it is a legal document, and this document can be used against the insured depending on what information is contained in it and how it's filled out. So let's start with some basics with a sworn statement and proof of loss. First, the policy dictates whether or not you have to give a proof of loss. Some policy provisions, like the one that's on the screen, requires the insured to give that statement within 60 days of their request. So that means you can wait for the insurance company to request it and then provide it. But there are other insurance policies that require the insured to give a sworn statement and proof of loss, regardless of whether it's requested, but trigger the obligation based on some time period after the loss occurs. That's a big difference because sometimes you can wait and see if the insurance company requests it, and if they don't request it, then you don't have to give it. But if the policy requires you to give it regardless of whether it's requested, then you have to do so. And it's a significant obligation because failure to timely and properly provide a sworn statement and proof of loss has been held to be a condition which the failure of which can negate or forfeit coverage under an insurance policy. Then comes the information contained in the proof of loss, which can be critical because the sworn proof of loss will often ask, what's the cause of loss? And so the information that you fill out on that line all by itself can be the difference between whether or not coverage is ultimately afforded and upheld under a policy. And then the statement will often require what the amount that's being claimed. That too can be very significant and affect what amount an insured is ultimately entitled to, and errors in the way in which that form is filled out can come back to hurt the client, to hurt the association if it's not filled out correctly.
Now, one of the last conditions we want to discuss today is the requirement to submit to an examination under oath. Now, an examination under oath is a requirement under pretty much all property insurance policies. And it's essentially a question and answer session where the association or insured will designate a person to appear on behalf of the association and answer questions about the claim. Typically, it's conducted by an attorney for the insurance company. These statements are done in front of a court reporter, and they are done under oath. So they definitely have the potential to, in the long run, if you ever go to trial, you could be confronted with this testimony somewhere later down the line. It's not yet in litigation, but the examination under oath is kind of akin to a deposition where the insurance company is trying to get additional information about the claim.
And you can be assured that if the insurance company has asked for an examination under oath, they have not done so with the mindset of that they're trying to figure out how to pay the claim. To the contrary, in the overwhelming majority of cases that I've handled, and I'm sure that Gina can attest to the same from the insurance company side and the work that she's done on the insurance company side, rarely if ever have I seen a situation where an insurance company requested an examination under oath and then shortly after had an epiphany and said, great, now that we have this examination under oath, we're going to pay the claim. More likely, and in fact, in almost every instance in which I have seen, in the hundreds and hundreds, if not thousands of claims that I've handled, the examination under oath is just another building block for the insurance company to put in the wall to ultimately determine that there's no basis for coverage or that there's some exclusion that they're going to be relying upon.
Now, we talked prior to this provision about designating a person on behalf of the association to appear and kind of handle the insurance claim. Now, under the law, the person who appears for examination under oath isn't expected to have absolutely all information about everything that's ever happened at the association property. But they have to have enough information and knowledge to be responsive to the insurance company's request. And with respect to that, again, the association really wants to take the time to determine who should appear and represent the association with respect to the insurance claim. If you represent and put someone forth for an examination under oath that has absolutely no knowledge of the claim and can't provide any relevant information, ultimately the court or insurance company may deem that you did not comply with this obligation to appear for an examination under oath.
One additional provision in insurance policies that most folks, even very sophisticated commercial property owners as well as lawyers, are not aware of is that insurance policies typically have an appraisal provision in the policy. An appraisal does not have the definition that most people associate with appraisal. It's not a real estate or a market value appraisal that the policy is talking about. Instead, appraisal is similar to an arbitration or an alternative dispute provision. And even though the courts have said that appraisal is not synonymous with arbitration, it's similar in the sense that typically what appraisal provides for is that the insurance company will have a representative of its company act as its appraiser. The insured will be entitled to have a representative on their behalf, And those two appraisers will attempt to determine what is the amount of the loss, not whether the loss is covered, not whether or not there's some exclusion, but just what is the amount of the damage to the property. And they will do so because there's a dispute between the parties as to what the amount of the loss is. And if those two appraisers, that is the insurance company's appraiser and the insured's appraiser, are unable to reach some agreement or consensus on what the amount of the damage is, then those two appraisers will agree upon the selection of a neutral or umpire to break the tie. And that's what appraisal is. There are a lot of other permutations with appraisal, but that gives you at least an overall sense of what appraisal is under an insurance policy.
Okay. One of the other considerations that associations need to be aware of when dealing with the insurance company is that the adjusters have ethical requirements. Michael had previously explained the definition of independent adjuster versus a public adjuster, but if you ever have concerns or questions about the adjuster's ethical requirements, they are available online. You can also look at the Department of Financial Services that outline the requirements for independent adjusters, and be aware that you do have rights under your insurance policy. So if you feel like an adjuster for the insurance company is acting inappropriately or misrepresenting any facts, there is some type of recourse, but we would suggest at that point contacting your association attorney or other insurance attorney who specializes in this area to discuss what your options may be.
So let's just a quick word just about experts, Gina. If you could talk a little bit about that, the different types of folks that an association might hire to assist them.
Absolutely. We already discussed public adjusters and the public adjuster's ability to assist the association in the event of a loss. You also have the remediation specialists, which we also discussed, and to be wary of certain contractual terms that are presented to you. One of the individuals that are often involved in an association claim are contractors. You want to make sure that if a contractor is hired by the association following a insurance claim, that that contractor be licensed, that that contractor be insured, that any of the transactions or payment to the contractor are done with some type of tracking history, whether it be by check or wire transfer. Avoid paying contractors in cash. You want to make sure that the people that you do contract with are not someone that you believe will not be around in a particular year. I know after Hurricane Wilma, there was a lot of kind of fly people putting themselves out as roofers, but then when the time came, claimed that there were some issues with the insurance claim and the roofer needed to be contacted or have some discussion about what repairs were made, those roofers were no longer available because they had either left the state or left the country. So just be very careful with who you contract with. One of the other things you do have to be very wary of is if a contractor or anyone other than a licensed public insurance adjuster tells you that they can adjust the claim with the insurance company or otherwise negotiate with the insurance company, they're likely breaking the law. The only people that are able to adjust a loss in the state of Florida are attorneys or licensed adjusters. So any contractor that tells you otherwise or represents to you that you should sign a contract to allow them to adjust the loss on your behalf, it may be an illegal dealing. You can also obviously hire engineers or geotechnical engineers. So now that we've talked about some of the post-loss conditions, what the investigation is going to be, the appraisal, ultimately, hopefully, you get paid on the claim. But, Michael, what happens if there's a denial of the insurance claim once this process is complete?
So if and when the association, the property owner, gets a denial of the claim, first off, that'll come in the form of a letter, and it'll set forth all the coverage reasons and exclusion reasons that the insurance company believes are the basis for its denial. And at that point, the property owner has really only two choices. The property owner can accept the denial, and meaning that the property owner is not going to pursue the claim further, or at that point, the property owner can retain a lawyer to file a lawsuit and argue that the denial of the claim was improper and constitutes a breach of the insurance policy, and seek seek a remedy, seek damages against the insurance company to recover the benefits under the insurance policy. Oftentimes, I will hear people come to me because they've received a denial letter and ask, well, can we get the claim reopened? Can we provide the insurance company with some additional information that perhaps will change their mind? And in fact, in denial letters these days, the way insurance companies write those letters, they almost always will say at the bottom of the letter, this denial is, of course, without prejudice to being provided with additional information that may change their mind. And if there is some additional critical information that the insurance company overlooks, you can provide that information to the insurance company in an effort to do so. Generally speaking, though, I would say that's a futile effort, and once you receive a denial letter, your only avenue other than accepting the denial is to then bring a lawsuit against the insurance company in order to recover. So that brings us to the end. You've been a great audience, and we truly appreciated the opportunity to speak with you today. Just two quick points. One, if you would like a copy of this PowerPoint presentation, you can contact Gina or me at Berger Singerman, and we would be happy to provide you with a copy of this presentation. In addition, both Gina and I have routinely gone out to associations and met with property managers and their property managers from around the state in order to speak on this topic as well as others, and would certainly be happy to do that in a different setting at your pleasure. So again, on behalf of Gina and me, and on behalf of Berger Singerman and our lawyers, thank you for giving us the opportunity to speak with you today.
Thank you.